appears that this hearing is not about electric vehicles after all. It does appear that this hearing is about scandal mongering. And not a week goes by that we don't hear another scandal involving American business, and not technical violations of the law, but knowing violations of the law that suggest a failure of a moral compass. But I don't know anything about eco-totality. I had not heard of them before yesterday in preparing for this hearing. I do not know their executives. I did not know anything about them. But I know that lightly substantiated charges like what we have heard now in this public setting can do real damage to an innocent company. There can be real collateral damage in companies upon which innocent people depend for their livelihoods, and in which investors have put some of their life savings. And before we make such before we make allegations like what we've heard today, there should be real substance to them. They should be well resourced. And if this hearing is about eco-totality, they should be there. They should have the chance to know what is being alleged about them, and they should have a chance to respond, to tell their side of the story. Fundamental fairness requires that. Common decency requires that. The failure to do it is an abuse of power. Now, there have been suggestions about eco-totality's political influence. They hired a lobbyist. Small towns in my district hire lobbyists to get grants to expand their water and sewer system. Hiring a lobbyist is not an unusual practice by anyone trying to get a grant. Dr. Hogan, what do you know of the politics or political connections in eco-totalities or any other companies getting an award under this DOE program?
The Department of Energy uses a rigorous, competitive, merit-based process for each and every award.
Okay. Was there any political influence by eco-totality in getting the award?
There is not political influence in any organization getting an award through any of these programs.
All right. And I don't know anything about the SEC inquiry. It has been reported that there is a pending inquiry. There was a subpoena issued at one point. When your office, I assume your office did learn of the SEC inquiry, and what did you do when you learned that there was an SEC inquiry?
So the timing of the SEC inquiry was well after this award was in place and underway. So it's important for us to have that information, but there is no proper action for us to be taking based on an SEC inquiry.
All right. Actually, Mr. Haas, I think I should have directed that question at you. When you learned that there was an SEC inquiry, what did you do?
Well, sir, I must preface my question by saying that we've done some limited testing with regard to this company and this particular grant. However, we hadn't done an in-depth audit of it. It is we have something scheduled in the coming fiscal year. However, we haven't done in-depth testing.
Okay. To any of the witnesses, did any inquiry into your own investigation into the SEC's inquiry into insider trading suggest that it was related to any DOE issues, any DOE grant issues?
All we know is that there is an SEC inquiry, and again, what we understand is that there's any number of SEC inquiries across any number of companies, and at the point we're at with an SEC inquiry, there is no action that DOE should be taking.
And in fact, there were 735 enforcement actions in 2011 alone, and no telling how many subpoenas were issued as part of those actions. Do you think a company should be disqualified from applying for a contract with the government, a grant from the government, because they have received a subpoena?
we believe it is actually improper for the Department of Energy to take the presence of a SEC subpoena into account at the point of running a competitive award process.
Okay. All right. Mr. Chairman, my time has expired.